We'll get going. It's 12:30 by my watch. So everyone who's joined in, thank you for joining. If anybody joins in after we've started, don't worry. Victoria Steele, our marketing coordinator, is going to be recording this, so it's going to be made available for you if you want to sit back for whatever reason and watch this again or catch up on anything you might have missed. Thanks for joining us. It's a Law with Lunch talk. Lucian, Bairstow and I are members of the employment team at Parklane Plowden. We're going to be giving you a talk on mitigation of loss, getting it right. It's a really dry topic. There's no way around that. We're going to come to why we're talking about it in a moment. And we appreciate you're on your lunch hour or lunch half hour, more likely. So we are going to try and make it snappy. The purpose of the talk and the reason why we're talking about it is it's had some airing, this issue of mitigation of loss recently at EAT level in the case of Edwards. We'll talk about that case very briefly later on. If you want a bit more detail about it and want to get an overview in a written form, you can go on our website, where a colleague of ours, Paul Sanger, has produced an article about that case specifically and about what the EAT was deciding. So Edwards is the most recent case on this point. It's very important that it's read by those who have a mitigation of loss issue in any case you've got. Paul Sanger's article is a good introductory process to that. The last thing I'm going to say is I'm going to apologize in advance for the amount of times I referenced the 90s hit sliding doors. It should become apparent why, but sorry for the repeated mention of that. The talk's in two parts. I'm going to talk about theoretical concepts principally first, and then Lucy's going to give you some practical guidance on some of the common arguments arising in mitigation of loss and how you can best shape your cases to argue them. So let's get going. What, when, and why now? So what is it? What is mitigation of loss? It's really in two parts. There's what's called mitigation of fact and mitigation in law. This is a talk really about mitigation in law. Mitigation in fact is simply past acts that have mitigated a loss. What is it? It's the duty or the obligation to not act unreasonably. And I'm going to come back to that in the next slide. When does this obligation or duty arise? It arises from the time that a common law or statutory wrong is committed. And what's that in plain language? Typically, it's from the time that the employee's been unfairly dismissed or some discriminatory act or tort has occurred, causing losses in income to arise. And why? Why is that a duty or obligation? Because any losses that you fail to mitigate, that you should, it's found that you acted unreasonably in not doing, those are not then recoverable. So that's why you have to do it. And why now? Edward and Tavistock. As again, say, have a look at Paul Sanger's article on the website for a review of that. So the headline test or question or issue to first be determined is, well, did the claimant act unreasonably? The claimant doesn't have to show that what they did was reasonable. Case of Wilding. And then the headline from the slide is, well, what's the difference between all of that? There is a difference. The more times you read the cases about mitigation of loss, and there are quite a few, the more times you realize that this concept of reasonable behavior, unreasonableness is elided and conflated, and sometimes the distinction isn't very clear at all. So as much as the case law repeatedly tells us there is a difference between acting unreasonably and the claimant not acting reasonably, are two different things. The reality is what you are focusing on is sort of the two sides of the same coin point. The first is, well, can it be shown that there was a course of conduct, there was an approach that the claimant should have taken that a reasonable person would have or could have? And if you can get over that, if you can show that, can you also show that what the claimant did, in fact, in not choosing that option or not going down that route, but doing what they in fact did, was unreasonable? That's probably the most practical way I would suggest you can look at the question of whether or not the claimant acted unreasonably. And it's not, again, for the claimant to show that what they did was reasonable. It's not a matter, taking the sliding doors analogy here, it's not a matter of looking at, well, simply what happened. You have to consider the counterfactual, the hypothetical, what could have happened, what was open to the claimant to do in a different world, And was that also something that a reasonable person could have done? That's only part of the test. And then you have to compare that really against, well, what the claimant did. And that would be, I would suggest, a practical way of looking at this concept of whether or not what the claimant did was unreasonable. Did they act unreasonably? It's a factual, not legal question. And what that means is there's not some set standard of behavior or set standard that the courts have set down to say that this is reasonable, this is not. It's simply a factual matter based on the facts of the case. It's combined subjective and objective. That's a little bit misleading as a headline. When you look at the case law, they are clear that it's for the ET or the fact finder to determine on a factual basis whether or not objectively what was done was reasonable or whether or not the claimant acted unreasonably. But the reference to subjective is there because what the courts also say is it's important that you're looking at this particular claimant. It's important that you consider their particular factual circumstances when then setting that against the objective assessment as to whether or not that's what a reasonable person would do, or whether or not a person acting reasonably would not have done what the claimant did. Despite all of that and those complexities, it's not actually a demanding standard. Case of Cooper and contracting reminds us, of course, we're talking about the victims of a statutory wrong or tort. It is not for the claimant to go above and beyond in trying to save the tortfeasor or the employer who has unfairly dismissed them money by doing more than they need to. They have to act reasonably, they cannot act unreasonably, but it's not a demanding standard to get over that threshold because, again, we're looking at it from the concept of they are the victim of the actual unfair dismissal. Can the respondent prove the claimant acted unreasonably? And this is critically important. Everybody on the call probably appreciates this, but applying it is a bit, and putting it into practice is different. The burden's on the respondent. Claimant doesn't have to prove anything. So what does the respondent have to prove? Again, apologies for the Gwyneth Paltrow reference, but again, sliding doors world, threefold test as to what you have to do. One, what steps the claimant should have taken, the date those steps should have been taken, and what the outcome of those steps would have been on the claimant's income. Come back in a moment to the case of what's called Gardner Hill, which is again a case referred to in the Edwards case. But essentially, that's the threefold process you should be going through to consider, well, in the counterfactual, in the hypothetical scenario that did not happen, what should the claimant have done? What was open to the claimant to do, and they could have and should have done? When should that have occurred? And what would be the outcome of that on that employee's income? Those are the things that the respondent has to prove. And so the evidence that it'll have to adduce to prove those will be, of course, things like what is it that the claimant could have done in terms of searching out for new employment? When could that have taken place? And what would that have meant in terms of the claimant's income? Not solely from a salary perspective, of course, but from a compensation package as a whole. What a respondent doesn't have to do, the case law is very clear about this, it doesn't have to prove that the claimant in fact would have been recruited into a particular job. I think in Edwards that's described as something which might, in many instances, be almost impossible to prove. So what isn't required is for the employer to establish that had a particular step been taken on a particular day, that the outcome of a particular application to an actual job would have led to that employee getting that job. That's not what the respondent has to prove. It has to prove that it was plausible, possible, it was open, it was reasonable for the claimant to have explored other avenues of income. When that could have happened, and it might be a variety of options, might be a variety of jobs. And the more, of course, jobs that you've got, the more powerful the evidence might be as to the likelihood that one of those jobs or one of those career paths would have borne fruit for the claimant. And then, of course, working out, well, had they acquired that, they would have either extinguished their losses or mitigated them further. So on that point, what does it mean for the actual losses that are claimed? Well, this then brings in the Edwards case. What the EAT in Edwards was clear to say was that it's not a good idea. We don't think that we are able to sanction the approach that the EAT took in that case of applying a percentage deduction to the losses. The facts of Edwards, very briefly, concerned an NHS employee, band 5, I think, who was considered not able to perform at band 5 level, was considered able to perform at band 4 level, but no work was provided to him, no jobs were offered. He eventually was dismissed. There was an unfair dismissal claim brought, and that was successful. When it came to remedy stage, the issue was, well, at some point in time, it was found that the employee, Mr. Edwards, could have and should have acquired employment in the back into the NHS, which would, of course, have an impact upon the pension part of the claim, which was obviously a significant aspect. It was presumably a care scheme that he was part of at the time that he was employed. When that time came, and the tribunal said, well, at this point in time, we can't really explain why the claimant would not have been able to or could not have obtained re-employment with the NHS. What it didn't do was say, well, that's the point in time then, if we go back to the previous slide, that's the point in time that that particular step could have been taken. And we're going to then work out the actual effect of that on his loss of income. What it did instead was it applied a percentage deduction to those losses ongoing. So it said, I think it was a 50% deduction that it applied. That, the EAT in Edwards said, is not something that should be done. It didn't say that there weren't occasions when it might not be appropriate. There's a whole separate talk that we could have about the concept of loss of chance claims and when loss of chance should apply to counterfactual scenarios in the past. That's an entirely different talk we're not going to go into today. But for our purposes, when one's talking simply about mitigation of loss, including remedy from a past event, the Gardner Hill case remains authoritative, and that case determines that you should be undertaking those 3 steps. What the steps should be taken, when should they have taken, and what would that have meant for the losses? So when you look at the last point on the slide there, from that point in time, the claimant's losses are either extinguished because the tribunal has found that the claimant would have acquired income which was sufficiently comparable or the same as what the claimant was receiving during his period of employment with the ex-employer, or it will be less than that, but it will then deduct those from any ongoing losses into the future. And that's the same as mitigation in fact. So if you were to take the example of a claimant who has lost their job, and between that and the remedy hearing has a loss of earnings of, let's say, £25,000, but 6 months into the losses, they acquired some income amounting to, let's say, £5,000, then that's a simple mathematical deduction of the £25,000, resulting in £20,000. The same process is undertaken for the mitigation in law when it's determined that at a point in time, that's when it should have happened. So it's as if it in fact did happen. So again, you just apply the deduction going forward from whatever that point in time is. What will all these steps look like? So what is it that the respondent in trying to prove that the claimant has failed to mitigate, what should those, might those steps look like? Well, here's a summary list. Some of these won't apply depending on the factual scenario. Online job markets, open accounts, activity, submitted applications. That's now pretty common in almost all remedy hearings that employment lawyers are involved in. You will expect to see, say for certain industries, almost all employees engaging in that kind of behaviour. A failure to do so, simply not engaging with that, is a red flag for whether or not the claimant has properly mitigated their loss. Registering with agencies, so job agencies, that might well be expected depending on the industry. Asking for references, that can be a red flag. If it's the case that no references have been asked for from the ex-employer, that might indicate that the employee is not actively seeking out future alternative income. Marketing on LinkedIn, of course, that's just one of the social media sites that might be used, but it's a common one used for people seeking out employment who are without work. A record of interviews and follow-ups, so actual applications that have resulted in responses from those potential employers. Those are disclosable, that's relevant evidence for remedy. The absence of that would suggest that maybe the applications are not being made, they're not being followed through by the claimant. Of course, if it's the case the claimant has submitted a lot of applications and can prove that, but then is able to themselves show that no interviews were obtained or no follow-ups to any interviews were given, That's potentially helpful evidence, of course, to a claimant who can show, well, they're making their best efforts, but it's a difficult market. The interviews aren't going as well as they'd hope, and it's not for want of trying that that they don't have the income that they used to. Throughout all of that, of course, the burden's on the respondent. Now, those are disclosable documents from the claimant, but every respondent and anybody who on the call acts for respondents will know it's no good simply just hoping and waiting for the claimant to deliver you evidence that you can then try to cross-examine on. Active steps have to be taken. So the moment, and again, I know it can often be the case that you may not be instructed until much later, long after the dismissal has occurred, but as soon as possible, even when you're focusing initially on perhaps liability, have in the back of your mind, we need to be, as soon as possible now, collating relevant evidence from the industry in which the employee worked and the employer works in order to paper a potential defence when it comes to the remedy stage. Internal vacancies, of course, for large employers, those can be easily obtained, but it's typically the case that you might be working for a smaller employer and there's no possibility of that employee finding alternative work within the organisation, and so you are looking at external work and external jobs. Contractor roles are a perfectly good evidence of ways to mitigate losses, simply because it might be a contract role or even a fixed term role. That doesn't necessarily exclude it from being a reasonable avenue to mitigate one's losses, particularly, for instance, if it's a part-time role. That then, of course, allows for the claimant to be searching for full-time work, permanent work perhaps, whilst not working during the part-time period that they have found a fixed-term role for. So those are some of the examples of the steps that you would expect to see a claimant being expected to take, typically following a dismissal or following a statutory wrong. So the last slide from me is really just a list. Lucy's now going to talk about, I think, if not all of these, most of them, in terms of drilling down into them practically as to how they can be argued and why they are common arguments. So I'm not going to go into it in any detail, but that's the list of things that we often see in remedy cases. So Lucy's now going to explore them. Over to you, Lucy. Oh, I'm just going to make sure.
Thanks, Gareth. Yeah. Right, so yeah, thanks, Gareth. So Gareth actually just touched upon in the what will the steps look like, a bit about the job search and suitability, but because it is one of the most, if not the most common argument raised by employers, obviously with the burden resting with them, that the employer's not made sufficient effort to look for work or that their search has been too narrow. I'm just going to expand on it slightly. Just a couple of practical considerations arising. So as Gareth said, and as we all know, hopefully on this call at least, burdens on the respondent, and they will need to have gathered evidence at the earliest stage. As Gareth said, that sometimes is to a certain degree out of our hands as legal advisors, because you're instructed at a late stage. Some of the larger organisations, as Gareth alluded to, will have internal vacancies, and some of those, I think particularly like the NHS, others maybe as well, do have online internal vacancy sites, which actually can be backdated to the relevant point in time. So that's something, if your employer is a large employer, to also bear in mind, but failing that at the earliest stage and continuing, when the client contacts you, give one of their personnel, somebody involved in the case, the job of collecting that evidence on a weekly basis. I mean, the reality is both parties will want their own paper trail. Like Gareth says, you can't sit back and expect all the evidence to come from the claimant and simply cross-examine on it. But equally, both sides will want their own paper trail if they're going to bolster their arguments. Once upon a time, I would have said it's one of those cases where you want a really heavy bundle that you're dragging to the tribunal. The sentiment remains the same, particularly from your respondent client. You want considerable disclosure. So talking about the actual vacancies and where the respondent's going to go to obtain that evidence, we don't just want evidence of the fact of those roles that were available. It's helpful, particularly for the suitability arguments, if you can obtain details of the roles that you're saying it was reasonable for the claimant to have applied for, or it's unreasonable for the claimant not to have applied for. So, easiest part of that is just to obtain job descriptions. which will be available if it's agencies that you're dealing with, and potentially online searches as well. Another point that's referenced on the slide there, I've gone back to front, I'm dealing with the respondent first, but down at the bottom is potentially a client might even consider sending the details of vacancies to the claimant. We don't want to be harassing the claimant, but similarly sending those as evidence that those were made aware to the claimant if they're arguing otherwise. And finally, for the respondent, or from the respondent's point of view, as Gareth said, the claimant may have evidence of, having applied for every job under the sun and saying, look, it's simply not the right market at the moment. So from the respondent's point of view, in any of these cases, potentially considering the opinion of a recruitment consultant, someone who can say how long it's likely to take somebody with claimant's skills and experience to obtain suitable, comparable, or otherwise new employment in the current job market, or if it's not going that far, somebody internally, some internal personnel that might be able to talk to common moves of other staff members in similar positions. Just again, touching very briefly on the claimant side of things, as I've already said, they may they will want their own paper trail, and they'll be wanting to record the steps that they've taken, as Gareth says, registering for agencies if that's relevant, online searches, etc. But also they want to be recording the reasons why any apparently suitable positions haven't been pursued. So advising your claimant client to keep a dossier, sort of diary, a notebook of those jobs that have come up that they haven't applied for, and what the issue was with them, whether it's home life considerations, childcare considerations, geography, or comparisons with the former employment. It's all helpful evidence that they can record the reasons why they weren't. And also potentially ask the respondent to assist with the job search. I mean, for example, if they did refuse or weren't particularly forthcoming, but are similarly arguing that the claimant's failed to mitigate, and the claimant has a clear pointer to put forward there. So moving on to the next slide, this is lower paid roles status. So refusing these can be a breach of the duty to mitigate. There's two cases there, well, three technically, because I've made reference to Edward at the bottom, but the two cases that are specifically referenced on this issue, Daly and Yetton, are actually both cases in which the court did not find a failure to mitigate. So the steps taken were deemed to be reasonable. But as Gareth said, and as is a theme running through this entire topic, it is all very fact sensitive. So whereas in Daly, in addition to dealing with other remedy arguments, including the claimant's loss of right to an extended notice period and other matters, the tribunal found the claimant's view, which was that he would remain unemployed rather than accept a role with a lower rate of pay than he was getting with his unemployment benefit. The tribunal found that that was reasonable, and the EAT accepted that it was reasonable also, but contrary to the tribunal's view, said that it was a loss that the employers were liable for, not the state. The loss was caused by his unfair dismissal. But importantly, the EAT did stress in that case that it would only be in special circumstances that such a decision would be deemed reasonable. And again, each case must be considered on its fact, is what was said. The case of Yetton deals with the linked situation where an employee starts their job search, looking for roles equivalent standing to that which potentially they were dismissed from or whatever, before then applying to lower level. So in the case of Yetton, the employee looked for employment at an equivalent standing for 6 months. And whilst the court commented that the employer might have lowered his expectations earlier, nevertheless, they did not find a failure to mitigate. It's also made clear the question of how long, again, is going to be a matter for the tribunal, an objective consideration for them to take on the facts. Just touching on the case of Edward before leaving this point, going back to his case, the claimant, as Gareth said, he'd been demoted, but not then deployed into a band 4 role, and that was then found to be an act of victimisation. So whilst the appeal, I mean, we've already referred you to Paul Sanger's article that deals with the case in detail if you haven't had a chance to consider it yourself. whilst the appeal against the tribunal's percentage reduction approach was allowed, it may well actually be the case that the claimant won't receive necessarily a significantly higher award. We all know from our own practical experience that it's quite common for the tribunal to simply say 3 to 6 months would have been a reasonable time and cap the losses at this point. So the tribunal found in Edward that at a certain time during his unemployment, the claimant should have started looking for band 4 roles, because initially he'd only looked for the band 5 roles. Provided at that rehearing, the tribunal applies the correct principles this time round and addresses its mind to whether the claimant acted unreasonably in failing to do so, when he would have likely obtained such a role, I think it is quite possible they'll come back with, say, a 3 to 6 or a 6 to 9 month period, and it not necessarily lead to a significantly higher award overall, but we'll see. So moving on to the next slide, this is about the remuneration package. So this really leads on from the arguments that we've just discussed about lower paid roles. So the EAT reminded us in Edward that tribunals are well placed and should make findings based on a broad evaluation of all the available evidence. Again, here is the area where the extent of the claimant's job search and consideration of suitable jobs can be challenged. It can be argued, or might be argued, that it's unreasonable not to accept a lower paid role if, all other matters being equal, the overall package is comparable. So one of the common, or I suppose main considerations here will be pension schemes. So it can be argued that the employee acted unreasonably, failing to mitigate their pension losses, but also their overall losses by not applying for roles with similar arrangements. So using Mr. Edwards' case again as a working example, he stopped applying for NHS roles, and the reasons will become clear when we move through the slides later on dealing with references, and instead applied unsuccessfully for a large number of roles in the private sector. Now, they obviously weren't going to give him the same pension arrangements, well, certainly not as beneficial pension arrangements as he had with his NHS pension. When eventually he did gain new employment, albeit on a fixed term contract, he was paid more than he had been, but again, the pension arrangements were not as beneficial. So the claimant has to have that borne in mind, and potentially lower paid roles may bring those better packages overall. So as I promised, moving on to references, the next slide, that's something, again, all these considerations, these arguments are somewhat interlinked. So when you're talking about the package or the roles that you're looking for, particularly there where I've made reference to NHS, as was the case with Edwards, the issue of reference is going to have to be borne in mind in considering whether or not you can say, well, it was unreasonable for the claimant not to have applied for such a role or not to have taken up such a role, particularly when looking at comparable packages. So again, Mr. Edwards' case is an example. The tribunal accepted that the claimant may have initially been discouraged from applying for NHS roles, and therefore the comparable roles that was going to bring with it the same beneficial pension arrangements, because there'd been a negative exchange with HR at the time of his dismissal, and that led him to believe that the reference would act as a, I suppose, further hindrance. But the issue of references can be a really difficult one, depending on your client. So often you're going to have internal rules or policies, or the client's going to have internal rules or policies, which is going to restrict them from being able to provide a reference that's any more than a factual one, potentially. You often have that situation in settlement agreements as well. And of course, if there's an issue or where your client has or may have to make referrals to safeguarding authorities or other regulatory authorities, obviously that's going to be fatal to the consideration of references, that then is going to allow the claimant to be able to mitigate in any way. So if a reference can be given, even if only a factual or narrative reference can be given, then get the client to do that. Essentially, you're enabling the claimant to mitigate their losses and therefore reduce the value of the claim potentially. Certainly, references that are too punitive, where they are unnecessarily too punitive, are going to prevent the claimant from mitigating and therefore increase the potential value of the claim. So if requests are received and can be given, do that. Similarly, and Gareth touched upon this as well, advise the client, particularly a respondent client, to look out for whether reference requests are being made or received by your respondent client in the early stages. If requests aren't being received, it's certainly a point in time where the employer can start to question what the claimant is actually doing, if anything, to mitigate the losses, how much effort's being put into it. And it potentially could therefore be used in settlement negotiations, encouraging withdrawal of certain claims or certain heads of loss, potentially. So references is a difficult one, but also potentially a useful one. Again, dealing with the Edwards case, just to finish off, because a point that arises from the reference again, by the time of the remedy hearing, as already stated, he'd been in new employment for 9 months. And albeit that was a fixed term contract, it was obviously going to come to an end, the tribunal considered that he was not only in a better position anyway, in respect of finding future employment, having had that second role, but also his new employer was then in a position to be able to provide him with a reference, him not having exited his employment in the same way he had with the respondent. So again, he wouldn't have to be as concerned as he had been about this negative reference. And so the tribunal again might take that into account in cutting down or capping those losses at that further point in time. I think they said in Edward it would be about 6 weeks after his fixed term contract with the new employer would come to an end that he'd be able to obtain the new employment, because he wouldn't have the concern, or as much of a concern, about a negative reference. Moving on to career change and retraining. Again, the case law varies as to the extent to which the employer is going to be liable, might be liable for lost earnings. In practice, it's going to be a question of remoteness of damage and the extent to which it's just equitable for the employer to support the training or the retraining. A lot's going to be coming down to the way that both sides' cases are framed. So for the respondent, can it prove suitable employment was available and not pursued, and that it was thus unreasonable for the claimant to use the dismissal as an opportunity to train? That's very evident in one of the example cases listed on the slide, which I'll come on to. On the other side of things, the claimant, can it be seen that they were actively searching whilst retraining, but as comparable employment isn't or hasn't turned out to be available to them, it's not unreasonable for them to put themselves into a competitive position by changing career or retraining. So the two examples, these are two examples in which it was deemed reasonable for the employee to have changed career or third. The EAT held that the claimant's decision to change career and undertake a 4-year university course was reasonable. Now, I said that one of these cases, this is it, or author talks about the critical point for the claimant. So in this case, the respondent was unable to prove that there was other available work that the claimant could or should have done. Perhaps their disclosure, their mitigation disclosure wasn't very good. But also the claimant took the decision to retrain and continued to look for work whilst undergoing the course. And her evidence, which was obviously clearly accepted, was that she would have stopped the course had she found suitable employment. So again, fact sensitive, definitely. The other example is Chula. This involved a security guard who'd been dismissed. I think the original allegation was for falling asleep on the job. The AT held there that he was entitled to retrain in IT. It was argued that the claimant, that the dismissal had deprived him of his clean record that he would need to continue in security, obviously, having found him asleep on the job. Further, it was said, having read the judgment, he wanted to put those poxy jobs, his words, not mine, behind him and concentrate on work in the IT field. So this is quite, I'd say, perhaps quite an extreme version. He made some 200 applications for work in IT, leading to 12 to 14 unsuccessful interviews. And then beyond that, went on to then do the course. So some of the findings were that he was considered an intelligent man by the court. He had an MSc in manufacturing management. And following those 200 applications and the unsuccessful interviews, he undertook a 3-month computer course and thereafter an intense 3-month course. But still not enough. In order to obtain a good job, he needed a qualification as a Microsoft certified engineer. And the evidence was that he hoped to complete that course within a further 6 months after the remedies hearing at a cost of £5,000 on top of the £1,300 loan he'd taken out for books and materials. But the tribunal found that he'd taken reasonable steps to mitigate his loss outside the security field, and the AT agreed. Wasn't perverse, it was open to the tribunal to find that it was reasonable for the appellant to retrain the computer field and it was reasonably foreseeable that this course would be necessary as a result of the unlawful dismissal. So fact sensitive, but that one perhaps not your run of the mill. Moving on to the next slide, setting up a business, becoming self-employed can be a reasonable step to take. Again, depends on the circumstances. But if it is found to be reasonable, the claimant is going to be entitled to compensation to reflect the costs and expenses incurred setting up, as well as lost earnings over the period in which they're doing that. Obviously, the flip side is any earnings from the business, or sums that have been earned during the mitigation period, will be deducted from the combined sum. So that's the flip side of that. Gareth's already referenced Gardner Hill. That actually involves a case of a claimant setting up a business after being dismissed rather than looking for a new job. It also involves a percentage reduction decision by the tribunal, but we won't get into that. The tribunal had held that he would not mitigate his loss. He'd spent 80% of his time setting up a new business, and his loss would therefore be reduced by 80%. The tribunal, the EAT disagreed and said, given the circumstances, the claimant had been a sole managing director of the respondent for 16 years, it was open to him to consider setting up his own business to use the experience that he gained. They found that the tribunal hadn't considered all the circumstances, but also, and I think probably critically, talking about how fact sensitive these are, the respondent hadn't been able to provide evidence to show that the claimant's actions were unreasonable. So I think it's definitely a balancing exercise. The last bullet point there, consider what disclosure we required. Obviously, thanks, Gareth, sorry. It's just considering that from your client's point of view. Obviously, that's going to involve some financial disclosure. It's not going to be simply an assertion that it was reasonable, or equally in terms of quantification. So consider that you're going to need information as to the type of business, when it was set up, but also profit and loss accounts, tax returns, and the like. So considering that at an early stage when formulating the arguments. So yeah, moving on to the next slide, if I can, which is the claimant's health, state of mind and confidence. I'm just going to touch on this super briefly because it actually just leads into the final slide about re-employment or offers of re-employment. So as Gareth already said, using that word sort of subjective, the tribunals are considering the individual claimant here. They're going to look at their circumstances to see what those reasonable steps might look like, whilst also considering this to be an objective test. When I'm saying that, they're going to look at health and state of mind, potentially confidence arising out of the events that have gone before the reason why you're in tribunal in the first place. If the claimant does suffer ill health, obviously it can affect the ability to mitigate, but the tribunal are going to expect some medical evidence in relation to that. These can't just be general bold assertions made with no evidence to support them. So just on to the next slide, please, Gareth, if I can. This is in terms of offers of re-employment. As I say, this lends itself to this whole issue of considering the claimant's state of mind, confidence, the position that they're in. It's going to be reasonable, and if the claimant's state of mind and confidence has been affected, then that's going to be relevant to whether it's actually unreasonable for the claimant to reject an offer of re-employment. The historical relationship between the parties is going to be relevant as well. Has the relationship soured subsequently, obviously with the proceedings that have ensued, or even potentially before that? They do need to be considered, and whether it makes it unreasonable for the claimant to accept it or transfer to a new role. And the two examples there, the first is Wilding, again, a case that deals with principles, and it's already been referred to by Gareth, but also the facts are addressing a re-employment situation. So the Court of Appeal upheld tribunal's finding that an employee had failed to mitigate his loss when he unreasonably refused his employer's offer of re-employment. So he'd said he wanted to go back to work, and the employer had made an offer of part-time work after the tribunal decision on liability, but before the remedies hearing. The employee then rejected the offer on the basis that he had no trust and confidence anymore. Notable, the parties had exchanged schedules of loss since the offer of re-employment. And so the employee was saying that the employer's, the respondent's schedule of loss boss was the last straw, the final straw. Tribunal considered all the circumstances, including the events before the offer was made, so before this souring or the schedules of loss being exchanged. In particular, it considered the employee's desire to return to work, as he'd obviously said previously, and the unavailability of other work, and concluded the decision to reject the offer was unreasonable. Similarly, De Beek, if that's in fact how you pronounce it, VAT upheld the tribunal's decision not to award compensation for loss of earnings to an employee who'd failed to mitigate by unreasonably refusing an offer to transfer to a new role with her employer in the British Army, in the Armed Forces. The VAT recognised that there are, which of course we'll all probably have had dealings with, discrimination cases where the employer's conduct has been such, or has caused such upset that it's unfair to expect an employee to make a rational analysis of an offer of re-employment. However, in that case, it was found that the employee was capable of making a rational decision. It wasn't one of those scenarios. She wasn't so disenchanted with the army that she couldn't have contemplated resuming a career within it. And furthermore, going back to the issue of suitability that we've considered at the outset or earlier on in terms of the job search, the new role that had been offered directly addressed the childcare problems that had arisen in her former role, and which had led her to resign and successfully claim the discrimination claim. So again, lots of fact-sensitive issues there, but looking at how these offers can be of use. Obviously, there will be a flip side where you may have respondent clients who, despite the findings of the tribunal, believe it's not a workable situation to have them back. But then the argument there is going to be that they're going to struggle more when it comes to arguing failure to mitigate. So things to definitely have borne in mind and to be advising the clients from at the early stage. So that concludes the slides and our talk. Thank you, as the slides say. Thank you very much, all of you, for joining and listening potentially whilst you've been eating your lunch. Hopefully it's been of some use to you. We're going to leave it there, but should you have any questions that you want to ask either of us, you may have noticed you won't have seen the slides in your own hands yet, but our email addresses were on the bottom there in the footers. You can always send us an email, and similarly the clerk's email address, obviously it's on a website, most of you probably already got it, but it's also reiterated on the front slide. So yeah, thanks very much, and have a good rest of the day. Thank you.